Good morning to you. I am Randy Thompson. I'm one of the partners at the Kerrigan, Estes, Rankin, McLeod, and Thompson law firm. And this morning, I'm going to be talking to you about an area of the law that attorneys call premises liability claims. Normal people, lay people, call them trip and falls and slip and falls. What I'm going to be talking to you about today is the general duties, responsibilities that a property owner owes to invited guests that come on the property. And it can be a grocery store, it can be a Walmart, it can be a Kmart, a big box store, Home Depot, Lowe's. It can be a private person's home. But there are certain duties that our laws, our judges, our case law has imposed upon people who invite others on their property. So that's what I'm going to talk to you a little bit about this morning. First and foremost, a lot of the clients who come and see me want to know, well, I fell on their property. Don't they owe me something? And the answer to that is no, they don't. The person who's injured, the person who falls, has to be able to prove that the store owner, the property owner, was negligent, that they did something wrong. And the case law has described premises liability negligence as failing to maintain the property in a reasonably safe condition. It doesn't have to be perfect. It doesn't have to be exact, but the law says a property owner has an obligation to maintain the property in a reasonably safe condition. And so I think the best way to understand what is a reasonable effort to maintain the property is if you walk on the property and you see a condition, whether it's a crumpled up rug at the front door, or a big spill, or broken glass, or sharp edges on corners. If you were to walk into that business and say, that's not right, that's an accident waiting to happen. Well, that's a pretty good definition of negligence. That's a pretty good idea of that store, that property owner is not doing a good job at maintaining their property in a reasonably safe condition. Of course, the problem is that there's no bright line. There's no absolute rule that says, yep, that's a bad condition. It all comes down to whether 6 people on a jury think, after hearing the evidence, after hearing and seeing photographs, if there are photographs, if those 6 people on a jury think, yeah, that's not right, that should not have been that way, then that's a pretty good idea of the store has failed to maintain its property in a reasonably safe condition. I gave you some examples of crumpled up rugs or spills that are on the floor or negligently stacked products so that the products fall off and hit somebody on the head. A business owner has to either create the dangerous condition or the condition has had to exist for a sufficient amount of time so that the business owner should have noticed the condition and should have taken steps to, 1, warn the customers about the dangerous condition, and 2, clean it up, fix it, resolve it. I've had a number of cases where rugs that are too lightweight or too thin are at front doors and customers come in and over and over and over again trip on these rugs, and it's because they're too thin and they're too lightweight. and they don't stay down on the floor in a flat manner. That's a great example of a negligent condition on the property that a property owner should know about. Other examples are when the freezer cases in grocery stores are leaking some kind of fluid out from underneath them. Sometimes it's simply condensation. Other times it's some oil that runs the machine that's leaking out from underneath the machine. But if the business owner either created the dangerous condition, for example, an employee mopping the floor with a wet mop and not putting up signs and then leaving the floor wet, that business owner created that dangerous condition. Or if it's a spill that's occurred on the floor and it's down there for a long enough period of time that the store should have discovered it, should have found out about it, then our courts and our laws say that a store owner, a property owner can be held responsible for any fall and subsequent damage that occurs. Florida is a comparative negligence state, which means that if your case goes to a jury, that the jury will be asked first and foremost, was the property owner negligent? Did they do something wrong? And if the answer to that question is yes, then the very next question that the jury is asked is, well, did you, the injured person, do something wrong? Did you do something to cause the accident? Were you not paying attention? Now, my experience is that jurors sit as Monday morning quarterbacks, and they always want to think about, well, I would have seen that sharp edge. I would have seen that oil spill on the floor. And so jurors tend to want, even if they find the store was negligent, they tend to want to put some fault on you, the injured person. But what we talk about in the trials and what we point out is, listen, the stores do everything in their power to keep your eye up on the products, right? They have these blinking signs of coupons that are trying to grab your attention. They want you looking at the boxes and the products on the shelves instead of looking down. A lot of times, stores will blame you, want to say it's your fault because of the type of shoes you were wearing when you went into the store. I'm involved in a case right now where my client was wearing flip-flops in the summer and went in to a grocery store, and there was a freezer case that was leaking oil out from underneath it. The store owner knew that it was leaking oil because they had some type of cloth towel material put down under the freezer trying to absorb the oil, but the oil spilled out into the aisleway, and my client fell and was significantly hurt in the fall. The store, the grocery store, wanted to blame her for wearing flip-flops in the summer in Florida. What was very interesting about that case is my client bought the flip-flops from the grocery store. She bought them from the store. So they want to sell them to you, and they want to then blame you for wearing them in their store, but they're glad to take your money when you come in the store wearing the flip-flops. But that's part of comparative negligence. Were you in a hurry? Were you watching where you were going? All of that is the store trying to put blame on you for your injury. The significance of comparative negligence in the state of Florida is that if a jury, for example, decides it's 50% the store's fault and 50% your fault, then you're only going to be able to recover half of your damages. So let me just talk to you briefly about damages. Damages are how you have been impacted by the accident. And the easiest damage is the medical expense caused by the fall. So if you fall and you break your hip or you break your arm, the surgery to repair the hip, replace the hip, fix the arm, those are part of your damages. But if you're 50% responsible for that fall, then you only get half of your medical bills. Damages also include lost wages, loss of income because you were unable to work at the time of the accident. Future medical expenses, if the doctors testify that as a result of this injury, you're going to have multiple surgeries, multiple procedures. And then, of course, what the insurance companies love to call pain and suffering. But what we know is how the injuries impact your life. Some of these falls leave people with very, very significant injuries. I've talked to you about shattered hips, broken shoulders, broken arms, broken legs. And those injuries can leave you in the hospital for a long time, can leave you in physical therapy, trying to get better, trying to learn how to walk with a new hip, and multiple doctor's visits, multiple physical therapy visits, multiple pain medications. So these are significant injuries that really and truly impact how a person can go about their normal life, how they go about their normal responsibilities, whether it's work, kids, farming, even to the pleasure parts of our lives, gardening, golf, fishing. All of these are examples that I hear on a routine basis of why clients come to me and say, this isn't right, this isn't fair. This is what happened to me when I went into this store. They knew that this oil was leaking out. This rug was crumpled up, and they told me as I was laying on the ground, yeah, people trip over that rug all the time. Or I was standing in the aisle and a box fell off of the top aisle and hit me on the head. We've had neck surgeries caused by premises liability claims. So they're very significant injuries. The statute of limitations, the amount of time that you have to resolve your claim or get it filed in a courthouse in Florida, is 4 years for a premises liability claim that left you injured. That doesn't mean that the claim has to be filed in a courtroom. Most of these claims never get in front of a jury because they get resolved, but you must get your case filed within 4 years of the date of the lawsuit. But I'm Randy Thompson. I am a board certified civil trial attorney. I am a little bit proud of that fact because I think there's less than 5% of us in the state of Florida. My email address is randy.thompson@kerrigan.com. If you have any questions, feel free to call or email me.